What will social justice warriors do once they run out of bigots to prosecute? At that point, I suspect the social justice movement will succumb to the equivalent of an autoimmune disorder. It will turn upon itself and destroy itself. In the fashion of earlier collectivist movements, there comes a point in every collectivist revolution, the Saturn phase, as it was referred to in the French Revolution, where the revolution devours itself. As social justice warriors run out of people whom they can audit for microaggressions, they'll start examining each other, using an entirely subjective and protean standard to decide who is the aggressor and who is the victim. And at that point, I suspect the movement will finally collapse under the weight of its own accumulated absurdity, and perhaps something akin to a free society can emerge. What happened in Oregon with the Sweetcakes case is a museum-quality exhibit of the dystopian logic, such as it is, of the social justice warrior movement. I need to explain something to people who are inclined toward what is sometimes called thick libertarianism, which is a perspective, as I understand it, that incorporates some of the concerns expressed by so-called social justice warriors. Hurt feelings are not evidence of a property crime. Property crimes require damage of some sort done against an innocent person and his or her real property, which is to say assault or theft or fraud. It has to be described as one of those categories in order to deserve the description of a crime. If you say something that offends another person, this may represent a terrible lapse of civility, but this is not a crime. And the person who is offended is not for the purposes of law to be considered a victim. Mere offense does not confer victim status upon the offended. What happened in this case in Oregon is that two profoundly unstable people who had been given custody of foster children as the result of a long and bitter custody fight with the grandparents, the natural relatives of those young girls, who are described as severely handicapped special needs children. After this long and envenomed custody battle, they were awarded custody of these foster children. This couple wanted to adopt these children, and in order to do so, they wanted to get married at a time when same-sex marriage was not legally recognized in the state of Oregon. They had an encounter with Aaron Klein of Sweetcakes by Melissa, in which they pulled something of a bait and switch. The young woman who visited Aaron Klein, Rachel Cryer, went in the company of her mother, who had ordered a wedding cake a couple of years earlier for her wedding ceremony. Aaron Klein met this couple at a bridal show of some variety. He wasn't told at the time that the cake would have been prepared for a same-sex ceremony. Once again, this is at a time when such ceremonies were not legally licensed in the state of Oregon. And as I've said on many occasions, marriage of any description should not be a state function. Government has no authority to license something which existed before its creation, which is the case with marriage. It wasn't until they were describing the inscription on the cake that the issue came up. At this point, Aaron Klein supposedly committed a crime by saying that his company did not produce cakes for same-sex wedding ceremonies, which once again were not legally recognized by the state of Oregon. As I have read Oregon's laws dealing with non-discrimination, I don't find anything in any of the statutes that says that what Aaron Klein did was illegal. The phrase refusal of service or denial of service does not appear in the Oregon Equality Act of 2007, which is supposedly the statute that was violated by Aaron Klein in simply refusing to take this couple's money. That statute is 158 words long, which is really a masterpiece of concision. And nowhere in the 3 sections of that statute is it said that you commit an act of unlawful discrimination simply by declining service to a would-be customer. It says that you cannot discriminate in accommodations. Aaron Klein accommodated this supposed victim, this would-be customer. He did not post a sign on the front of his business saying that this public business is not open to homosexuals. Under the Oregon law, that would be considered unlawful. I would consider that to be an exercise of property rights. But under Oregon statutes, what people in that benighted state are required to pretend is the law, you couldn't post such a sign. That's something which is specifically addressed in the statute and in related statutes in the Oregon Revised Statutes. There's nothing in Oregon state law that says that after extending accommodations to a customer, you have to supply the specifically requested service. You could simply say, we don't provide that service. Banks do that sort of thing all the time. If you go into a bank and ask for a particular type of a loan, they might say, we don't offer that type of a loan. If you go to a service station or a restaurant, they might say, we don't offer that particular good, that particular service. If you go to a pizza restaurant, you cannot order sushi. These are all acts of denial of service. They're not necessarily the sort of thing that would be considered invidious discrimination, but they're all examples of a public accommodation that invites the general public to partake of its good or its service that does not provide every conceivable good or service or every imaginable permutation on the same. So there's no statutory authority for describing what Aaron Klein did as discriminatory, but it hurt the young girl's feelings. She was devastated. She left the room in tears, and her mother consoled her, and then they took a brief trip in the car, and then they turned right around and came back so that the mother could confront Aaron Klein in the absence of this distraught young girl who wants to be a parent once again. And she was so pixelated, so devastated by a trivial social snub that she completely lost her composure. And the mother, who was burdened with a sense of mission to correct this homophobe in his thinking, went back to confront him, and they had a brief exchange that involved a quotation of scripture. The mother then came back out to the car and exacerbated the mood of this distraught young woman by claiming, dishonestly as it turns out, that Aaron Klein had described her as an abomination. And that phrase was included in the complaint that was filed with the Department of Justice on the following day. That was something that was said outside of the presence of Rachel Cryer, the young woman in question. It was a dishonest paraphrase, as it emerges from testimony, of what Aaron Klein had actually said. But her feelings were hurt, and because of her identity as a member of a specially protected class, her hurt feelings meant that she had suffered an injury and was owed redress through the redistributive powers of the punitive state. When I come back, I'm going to take as long as required to read the 20-page summary of the findings of fact in this ruling. This is going to be somewhat tedious, but I think it's a useful exercise. This is Will Grigg with Freedom Zealot Radio. Stand by for more sedition after this.